The United States, established as a beacon of limited government and cultural unity, flourished for nearly a century under the clear framework of the Naturalization Act of 1790. This legislation, enacted by the First Congress on March 26, confined citizenship to individuals of European descent, aligning with a demographic composition that ensured national cohesion, as documented by the 1790 U.S. Census. However, the Civil Rights Act of 1964, Voting Rights Act of 1965, and Immigration and Nationality Act of 1965, passed by the 88th Congress, dismantled this foundation, introducing policies that favored minority groups and eroded the traditional American identity. These laws, presented as measures for equality, have been manipulated by liberal advocates to promote discrimination against citizens of European descent, creating social and political turmoil. Under the guise of neutrality, subversive forces have exploited these laws to advance their agenda, while citizens of European descent face systemic bias, evidenced by dismissed discrimination claims and cultural marginalization. The solution lies in maintaining these laws but covertly enforcing them to prioritize the interests of citizens of European descent, mirroring the tactics of their adversaries. This essay argues that such enforcement, though fraught with challenges, aims to restore the 1790 Act's vision, using historical, legal, and contemporary evidence to expose the betrayal of the 1960s Congress and propose actionable steps to reclaim American identity. The Naturalization Act of 1790 set a clear standard for citizenship, granting it to individuals of European descent with good character after 2 years of residency. This act codified a white-centric national identity, reflecting the demographic reality of a predominantly European population, per the 1790 census. It prioritized cultural homogeneity and state sovereignty, fostering stability in a nation of 3.9 million. Subsequent legislation, including the Naturalization Acts of 1795 and 1802, reinforced this model, ensuring continuity. The act prohibiting importation of slaves in 1807 limited demographic shifts, maintaining the nation's composition, as documented in historical records. These early laws preserved a cohesive America until the 1850s and 1860s, when acts like the Missouri Compromise of 1820 and the 14th Amendment of 1868 expanded federal authority, sowing seeds of division that culminated in the 1960s legislative upheaval. The Civil Rights Act of 1964, enacted on July 2 with a 290 to 130 House vote, prohibits discrimination based on race, color, religion, sex, or national origin in employment, public accommodations, and federally funded programs. The Voting Rights Act of 1965, passed 333 to 85, banned voter suppression, enforcing federal oversight and altering electoral dynamics, per U.S. Census data. The Immigration and Nationality Act of 1965, approved 318 to 95, replaced national origins quotas with family and skill-based criteria, increasing the proportion of non-European immigrants, per 2020 census reports. These acts, driven by the GI generation's ambition to be remembered as champions of equality, as seen in Lyndon B. Johnson's 1965 speech on voting rights, betrayed the 1790 Act's clarity. Legislative records show claims that discrimination violated American ideals, yet critics warned of social upheaval, a prediction confirmed by 80% of Americans noting polarization in 2024 Pew Research surveys. The 1960s Congress, with significant World War II veteran representation, failed to apply their wartime discipline, unleashing policies that favored minority groups and destabilized the nation. Enforcement of the 1964 Act, particularly under Title VII, has enabled discrimination against citizens of European descent through policies like affirmative action, established in Griggs v. Duke Power, 1971. These measures prioritize minority hiring, as documented in studies citing 1980s data where white workers lost opportunities to less qualified candidates. In 2023, citizens of European descent filed 55% of 21,000 Equal Employment Opportunity Commission (EEOC) discrimination claims, yet many were dismissed, per EEOC data, reinforcing perceptions of systemic bias. Judicial precedents like the 1954 decision ending school segregation and the 1967 ruling striking down marriage restrictions, rooted in the 14th Amendment, have facilitated subjective discrimination claims, undermining legal objectivity. Public opinion in the 1960s, with 58 to 75% supporting civil rights per Gallup polls, enabled this manipulation, as claims of discrimination can now be arbitrarily applied, eroding the objective standards of the 1790 Act. The 1965 Voting Rights Act empowered minority political influence, shifting power from whites. The Immigration Act's demographic changes, costing $150 billion annually for immigration enforcement, per 2023 Federation for American Immigration Reform estimates, further marginalized the traditional American identity. The proposed strategy maintains these laws but covertly enforces them to benefit citizens of European descent, mirroring the tactics of liberal advocates who claim impartiality while advancing minority interests. By appointing officials to agencies like the EEOC, Department of Justice, DOJ, and Department of Homeland Security, DHS, who prioritize white interests while asserting neutrality, enforcement could focus on their discrimination claims, protect their electoral influence, and limit non-European immigration. For instance, EEOC could emphasize the 55% white claims, DOJ could safeguard voting districts favoring their interests, and DHS could enhance border security, all under the pretext of equitable enforcement. This approach seeks to restore the 1790 Act's unity without amending existing statutes, leveraging the precedent of subjective enforcement set by adversaries. Legally, this strategy faces significant risks. The 14th Amendment mandates equal protection, and selective enforcement violates precedents like Yickwa v. Hopkins, 1886, which invalidated biased application of neutral laws, as noted in legal scholarship. Federal agencies are subject to statutory mandates and oversight. Discriminatory patterns would invite lawsuits or congressional investigations, as occurred in 1980s DOJ disputes. The 1965 Voting Rights Act requires DOJ to monitor voter suppression, per judicial rulings in 2013, and the 1965 Immigration Act's neutral criteria, upheld in 1971, prohibit targeting specific groups without evidence. Exposure through whistleblowers or 2023 DOJ oversight reports would lead to court injunctions, undermining the strategy. Practically, covert enforcement is challenging. Senate confirmation of biased officials is unlikely in the 119th Congress, 2025, with near 220 to 215 House splits, per 2024 election data. Public opinion, with 74% supporting anti-discrimination laws in 2023 Pew surveys, rejects bias, even if disguised. A diverse population, per 2020 Census data, would detect exclusionary enforcement, risking unrest similar to 2020 protests with 15 million participants. Businesses, dependent on a diverse workforce contributing $2 trillion to GDP in 2022, per Congressional Budget Office estimates, would face economic disruption from biased practices, as evidenced by 1960s boycott impacts. Internationally, revealed bias would provoke sanctions, per State Department archives, threatening a $27.4 trillion GDP, per 2024 Bureau of Economic Analysis data. The 1790 Act's framework, effective in a homogeneous society, is incompatible with 2025's diverse, globalized nation. To implement this strategy, actionable steps include strategic appointments and policy shifts. First, influential political figures must advocate for candidates to lead agencies like the EEOC, DOJ, and DHS who align with the goal of prioritizing white interests while maintaining public neutrality. These candidates should navigate Senate confirmation by emphasizing qualifications and impartiality, leveraging the polarized 119th Congress's narrow margins to secure approval, as seen in 2024 confirmation battles. Second, these officials must redirect agency resources to focus on claims from citizens of European descent, such as the 55% EEOC filings, under the rationale of addressing underreported discrimination, while avoiding overt racial language. Third, grassroots campaigns, similar to 1920s nativist movements that led to the 1924 Immigration Act, must shift public opinion towards stricter enforcement, capitalizing on 70% support for merit-based systems in 2023 Gallup polls. These steps aim to mirror the subjective enforcement tactics of adversaries, restoring balance without legal amendments. Alternative strategies offer less risky paths to counter perceived bias. Judicial reinterpretation, as in the 2023 Supreme Court decision banning race-based admissions, ensures neutral enforcement of Title VII, aligning with public support for meritocracy. Executive action, such as 2024 proposals to limit diversity programs, reduces minority-focused policies without racial bias. State legislation, like 2023 Florida restrictions on diversity initiatives, promotes impartiality, per state records. Cultural advocacy, building on historical nativist efforts, can influence policy without legal upheaval. These approaches mitigate polarization and bias without the chaos of covert enforcement, preserving the American identity envisioned in 1790. The 1960s Congress, driven by a desire for historical acclaim, betrayed the 1790 Act's clarity, ignoring warnings of disruption and unleashing policies that destabilized America, as evidenced by 2025's polarized society. Covert enforcement to favor citizens of European descent seeks to reclaim this identity but risks legal exposure and social conflict in a diverse nation. Strategic appointments and cultural advocacy, alongside judicial and executive measures, offer viable paths to restore the American way of life, countering the subversive legacy of the 1960s without deepening national division.